G'day everyone and welcome to another video for the Legal Studies guy, or another update actually. This is the second time we've shot this one. We are currently looking at area 3.2.7. So over halfway now and getting deep into our area on civil law and responsibilities of key parties today. It's a good quote here from Bill Copeland. The trouble with not having a goal is that you can spend your life running up and down the field and never score. It's the idea of, in a way, what's even the point of getting up every day if you're not actually working towards something that you're striving for. It sort of almost means there's no purpose to it. And U12 is a great example of that. I mean, sometimes the goal is as simple as wanting to do well, and that can be enough to, help you have some purpose and direction with your Year 12 stuff. But if you can even try and get more specific with that about, what you actually want to be doing, not necessarily in 5 or 10 years' time, but just next year, and I suppose how you want to feel at the end of the year and what you sort of need to maybe feel that way or get where you want to go next year, it can just build a bit more purpose and structure into everything you do. So I know it's scary to think about what the goal might be and what the future might be, but the net benefit of it, even though that is a bit scary, is really, really big. So definitely worth trying to have a think about what you're actually working towards and why. As I said, it's 3.2.7. Our dot point, our knowledge here today is the responsibilities of key personnel in a civil trial. Now, this directly matches the dot point from 3.1, which was the responsibilities of key personnel in a criminal trial. And we need to know about the exact same personnel: the judge, the jury, the parties, and the legal practitioners. The sort of questions you can get on these are then really broad. We're really going to focus on this idea of discussing their responsibilities today, like we did in the criminal law video update. But remembering as well that last year's 10 marker on the exam was literally about juries. So one tiny little subsection of this dot point, juries in criminal and civil trials and how they promote the principles of justice. So we do need to know specifically what the responsibilities are. We then need to be able to discuss those responsibilities, and then obviously we need to know how they link back to the principles of justice as well. So even though it's a pretty straightforward dot point, there's quite a lot of meat here and quite a lot of things we need to do with it. But essentially, we're just trying to, from a knowledge viewpoint to build off, which is, the building block. We need to know the responsibilities first. We just need to be able to answer the question of what do the key personnel in a civil trial do. So starting with the judge, and look, you'll see that this pretty much mirrors a lot of the stuff that were in those criminal law responsibilities. In the first instance, the judge is more or less the boss of the courtroom. They're that impartial third party. So the rules of evidence and procedure, they enforce those. They rule on the admissibility of evidence when applying those rules of evidence. They basically, dictate who goes when and what goes next and make sure that the right process is followed. If any questions of law arise, they address those. So, what is the meaning of Section 58 of the Wrongs Act, for example? They'll decide that and tell the parties what that ruling is, what that wording means, which then helps the parties further develop arguments, etc. Obviously, juries are optional in civil cases, but if there is one, the judge will direct them like they do in a criminal matter. If there's no jury, they'll decide a remedy. They decide a sanction in criminal law, and they'll also decide the remedy in defamation matters, even if there is a jury present. And then this big one here will focus a lot more on the judge, because the next dot point is the case management powers of the judge, and that really goes into even more detail about basically everything the judge can do, the different responsibilities that the judge has, and that'll give you a bit more weight around, the role of the judge and the responsibilities that they play. The jury, again, really similar to a criminal jury in the sense that when there is one, they follow instructions from the judge, they objectively listen to evidence, and then they deliberate until they reach a verdict. The difference being that they're not compulsory like they are in criminal matters, they're optional, and they're only a jury of 6. And with these optional juries of 6, either party can elect to have a jury, and if that party is electing to have the jury, they then must pay for it. So having a jury in a civil matter is an added cost. So that's important to remember, that there's an added cost to having a jury, and that's something that you can factor into, when you talk about access and cost and taking cases to court and stuff like that. You can say, and if the party wants a jury, there's an added cost there. They also, in civil cases where there's a jury, unless they're defamation, they also decide on, the red's not really good over here, but they also decide on the remedy. So that's something a little bit different than a criminal jury, who don't decide on the sanction. It's purely with the judge. In a civil matter, the jury will decide on a remedy except defamation, and the whole idea there is that with defamation, I suppose the vagaries around how much someone's reputation is damaged and how much money that's worth is something that maybe a jury's not adequately able to decide, considering they're not legally trained, which is one of the things we always go back to. But outside of that, like personal injury, if you've got a jury, things like that, the jury will also decide on the remedy. So that's a really good responsibility that you can put into an answer, unless it's defamation, obviously. Now, the parties, and I've updated this a little bit because of some of the info that was on last year's exam about the Guy and Tom case, which I'll talk about as our skill later on. Look, the simple stuff is that there's 2 parties. Those 2 parties are the plaintiff and the defendant, or 2, I suppose, groups of parties, the plaintiff and the defendant. We know that some civil disputes can have more than one plaintiff, be that more than one individual, but it also could be insurers who get involved in claims. We know with class actions you can have, thousands of people who are suing the same person, and there can also be multiple defendants. So a great example is the bushfires, the Black Saturday bushfires class action that included the company that owned the power lines were sued, the company in charge of the maintenance of the power lines was sued, and then the Victorian government was sued for their emergency response. So there can be multiple plaintiffs and multiple defendants in a dispute, but ultimately there are just those 2 main parties who are engaged against each other. The really important thing in civil law is that both parties are fully responsible for their own case. So we call this party control, and you can actually say party control in an answer, and an assessor will know what you're talking about. So the concept of party control is that each individual party, the plaintiff and the defendant, have to gather their own evidence. They have to develop their own arguments based on this. If they want legal representation, they have to get it themselves. It's not provided to them. You don't rock up to court and have a lawyer there. So you have full control over your own case. Obviously, the plaintiff is attempting to prove the claims, balance of probabilities, and the defendant is casting doubt on them, trying to prove that, they didn't cause the harm or they weren't responsible for the harm. The whole idea, again, of party control is that, no one else is going to do it for you, and this is the really key important thing to get across if you're talking about the responsibilities of the parties, is that you've got to do it yourself. So obviously you usually get a lawyer, but the idea of doing it yourself can go right through into trial when you talk about presenting arguments and you talk about, questioning witnesses, but you can also talk about the responsibilities pre-trial. So party control means you've got to prepare your own pleadings to initiate the dispute. You've got to figure out what documents you need and request them during discovery. You've got to provide the documents during discovery. So partaking in all those civil pre-trial procedures is also one of the responsibilities of the parties due to this idea that you have full control over your case. Another really big one is this idea, or not this idea, this pure fact that both parties are subject to the overarching obligations. Now, in Victoria, civil lawsuits are covered by the Civil Procedure Act. So it's an Act of Parliament from 2010. And it basically runs through in extensive detail how a civil lawsuit should work in the Victorian courts and all the rules around that. So this is more or less the Civil Procedure Act is what a judge will enforce as part of one of their responsibilities. But the opening to one of the opening sections of the Civil Procedure Act is this idea of overarching obligations. And these are these kind of principles that every party to a civil dispute must follow. So the overarching obligations apply to any person who is a party. And they also apply to legal practitioners, which we'll go into a bit more in our next slide, plus law firms, insurers, litigation funders, etc., which we don't really need to know about. But focusing on parties have to meet the overarching obligations and legal practitioners do. And these are the overarching obligations. And the beauty here is if you're asked to talk about a responsibility of the parties, you can actually say one responsibility is to meet the overarching obligations. So that's like identify, meet, let's just call them overarching obligations, the OOs. And then the way that you can show that you understand that when you actually have to explain it, so if you're asked to explain one responsibility, is you can just actually detail some of these. You know, these include these things here. So the overarching obligations, as you can see from the list, act honestly, straightforward, don't lie. Actually have a proper claim, don't bring vexatious lawsuits for the sake of bringing lawsuits to piss people off. You've got to have a basis for your claim. Cooperate, try and resolve the dispute, don't mislead, again, act honestly, narrow the issues as much as possible, ensure costs are reasonable, minimise delay, disclose documents. So really straightforward, but basically a really clear list of things that you need to do to make sure that the dispute is resolved as quickly and as fairly and as cost effectively as possible, which we know really meets our principles of justice. Do particularly say companies, if they're engaged in a lawsuit with an individual and they have high-powered legal teams, etc., do they maybe do very good at, these things and minimising delays and narrowing the issues? Maybe not, but it is listed in our Civil Procedure Act that these are. So really, really good one. What's the responsibility of the parties? Well, one responsibility is to meet the overarching obligations from the Civil Procedure Act. These are a set of guidelines that parties to a dispute must follow, such as acting honestly, cooperating, taking endeavours to resolve the dispute. Really good answer, and you don't need to really know that much in detail to do that. As I said, and look, if you just, we'll keep those. If you want to go to it, it's really easy. If you just Google Civil Procedure Act, you can go to the OSLI website and this is the Civil Procedure Act. And you can see here, basically straight away, we're only at section 10 and we're already into the overarching obligations. And here's detail about all of them. So, for example, if I click on 26, it will tell me a person to whom the overarching obligations apply must disclose the existence of all documents in that person's possession, custody, or control, which the person considers, so point B here, if I can highlight that, which the person considers are critical to the resolution of the dispute. So, aka the idea of discovery is a pre-trial procedure. You have an overarching obligation to disclose to the other party any documents you have that you think will resolve the dispute. Whether they help you or they help the other party or not, you must, if you know you have them, hand them over. And like even here, to avoid delays, a person to whom the overarching obligations apply must only take steps that they believe will facilitate the resolution of the dispute. So don't take steps to try and elongate the dispute, basically, which is really common sense, but is actually really clearly enumerated and means you can put it into a good answer. So they're the overarching obligations. Legal practitioners, they are subject to the overarching obligations as well. And then some of the really clear responsibilities we want to talk about here are, say, with barristers, we present the case at trial, which means opening and closing addresses, if you want to get into specifics, and questioning witnesses. So you can talk about that. Solicitors, administrative support, we're talking about things like preparing pleading statements of claim, preparing documents as part of the discovery phase, etc., etc. So they're the specifics you can get into with legal practitioners, but pretty straightforward. Judge, parties, legal practitioners, and jury, obviously. And then this is our skill. And we spoke about this over when we did the dot point on criminal law. What does it mean to discuss the responsibilities? And I've said before that previously my interpretation of this was what they do and then what they don't do. But we had this question on last year's exam that really kind of finally, and a lot of people were doing this right already. That's not to say that this probably surprised less people than people who are probably already doing it right. But this question around Guy being the victim of an attack by Tom, he suffers significant injuries, onwards. And basically, he wants to sue Tom for his medical treatment and his loss of earnings. And we got to ask this question to consider or discuss the responsibilities of both parties. And what this basically meant, as we found in the examiner's report, discussing the responsibilities of both parties meant to explain the responsibilities. So, as we've done in plenty of answers before, really clearly say this is a responsibility and then explain it. And then the discussion was to then explain what we would say is a limitation of this. So an issue that it causes. So basically say one of your responsibilities is obviously to present opening and closing addresses because you have party control. This means that you are responsible for, presenting your arguments to the judge, etc., etc. However, a limitation of this is that you need legal representation, and in this instance, we know that Guy is unable to afford it. So basically, explain the responsibility, then look at a limitation of it. So I've got some really clear examples here, and I won't just read through this. You can easily just copy this down yourself, and it's pretty understandable. But we've already gone over what the judge does around instructing a jury applying rules of evidence. And one of the limitations of this is that they can't assist unrepresented parties. You could also maybe potentially look at, the fact that we don't have juries for every matter. So are we able to... could you look at the fact that maybe one individual deciding a matter might not be as free from bias as six? It's not the strongest bit of evidence in terms of a limitation, but something you potentially look at as well. Juries, they deliver a verdict, except in defamation, they decide on a remedy. What are the issues or the limitations of this? They're not legal experts, they might have bias. And they're expected to decide on monetary awards for parties, and they're not legal experts. Like, that's maybe a little bit dodgy. Barristers, opening, closing addresses, examine witnesses. The limitation of this is their expense. Solicitors prepare evidence, prepare witnesses, writ statement of claim, affidavit of documents, do all of that. Again, limitation issue with this is expensive. It adds cost. There's so many ongoing fees. My colleague who I teach the subject with and the kids at Horsham College would know this. He's talked about this. He's talked about when he was a lawyer working on a major case, and him and 5 other solicitors being given a more or less a file or an electronic file that had, I think, approximately it was either 20,000 or 200,000 emails in it, something along those lines. Just a huge amount. And basically, they spent nearly 6 weeks reading every single email and deciding whether it was relevant to the dispute and useful or not. So basically, that was their job for 6 weeks. They're charging the client somewhere around $300 an hour each to do this. That the law firm's obviously taking that money, but it just shows that as those ongoing fees pile up for that preparation of evidence, etc., the expense in pursuing a civil matter is huge. A real limitation, and particularly in this case, we know that Guy can't afford legal representation, so he's certainly not affording solicitors to be combing through evidence. Obviously, this isn't a super complex dispute. It's a injury case where there's been an assault, but you can again just start seeing how these might add up. And then plaintiff and defence, they have party control. That's their responsibilities. And what are the issues? Well, you probably need representation, and the complexity, if you can't get representation, means you maybe don't have access because you don't understand it, and that applies for both. So this was a sample answer out of last year's exam, and it really just goes into some of those things I talked about. So it says both Guy and Tom have responsibility of presenting their case. What does that mean? Well, they cross-examine witnesses, they sum up facts, they have the same opportunity to. Basically, that's what they do. That's one of their responsibilities. So what are the issues with this, the limitations? So here's the discussion. However, really good signposting showing where we're going with the answer, so important. Since Guy is financially disadvantaged, he can't afford legal representation, so he might be at a disadvantage to Tom if Tom can afford a lawyer. This means they might not be on equal footing. That's an issue. So we're seeing the discussion here. Here's their responsibility, and here's how it might be an issue in this instance. Really important that we're linking to the case. Again, party control. Tom and Guy have full control over their cases. They're able to decide what they disclose, who they call up, what evidence to present, etc. So it gives you detail, and Tom and Guy therefore have full agency over their cases. Really straightforward and clear, states a responsibility, then provides some detail to back it up. Limitations, however, they might receive minimal assistance from the court. Guy, again, looking like he won't have a lawyer, which means he might be disadvantaged because he's not getting help and support because he's fully in control. This means, due to his lack of understanding, there might be further delays. He might miss vital evidence. Basically, the issue is he's going to be behind the eight ball. He's going to be on a lesser footing than Tom based on his lack of representation, and the way the responsibilities are structured means he's not going to get help from the judge or the court. So that's the limitation that comes with party control. Is it means that sometimes, particularly if you can't get a lawyer, someone who doesn't have legal knowledge and understanding is trying to run a case, which isn't going to end well for that person. As always, as I said at the start, we need to know this stuff. We need to discuss its limitations. And then we always need to be able to link back to the principles of justice. And that was that 10 marker on last year's exam, just around literally juries, fair, equal, accessible, criminal and civil trials, 10 marks. So tiny like a little subsection of this dot point, one of the 4 things, and it was the entire breadth of the 10 marker. So we must know how it all links back to the principles of justice. It's really the same as criminal. And you can go a lot further with this as well. You know, you can talk about the issues with juries not being trained to put aside prejudice and biases. Should be that, I'm pretty sure. But you could also talk about the lack of fairness with juries deciding remedies, knowing that maybe they're not the best place to do that, and we might end up with juries deciding different remedies for similar cases because juries change, obviously. Both parties are on equal footing with party control, but you know, juries are also optional. But then also, what if one party has better representation? How does that hit with equality? There's a lot more that you can put in here than I've just got on this slide, but this is just some good starting points around the principles of justice. As I said, I'll link you the Civil Procedure Act in the description below, but hopefully at the initial base level, you can really clearly just outline some of the key responsibilities of these personnel in a civil trial. Perhaps that the judge runs the show, perhaps that parties have control, perhaps that juries decide on a verdict, and that lawyers more or less assist parties in some of the specifics of that. That's the base. You build from there into some of the more depth around that. What are the overarching obligations? You know, when do juries decide remedies and when don't they? So that added depth, and then you start talking about what are the issues with this. What are the issues with party control? What are the issues with juries deciding remedies? What are the issues with judges being not able to help unrepresented parties? And that's more or less how you build into being able to address the prompts you're given on the exam. As always, reach out if anything's unclear, if you think anything's false, wrong, or anything needs more clarity. But yeah, hopefully that helps you really start getting across the line on those key personnel and their responsibilities in civil matters. Cheers.